everyone, and welcome back to Gateway Spotlight, a series focused on current issues impacting international higher education in the United States and around the world. My name is Harvey Charles, and I'm the host of Gateway Spotlight. I've been in the field of international education for more than 30 years, having served as SIO and Professor of International Education at multiple institutions across the United States. With federal action and duration of status anticipated any day now, institutions across the U.S. are scrambling to determine the potential implications of these actions on their operations and what might be the most responsible and strategic set of responses if these actions are implemented. In this episode of Gateway Spotlight, we will examine emergent federal actions and evolving policy signals. We will discuss possible implications for F1 and J1 students and scholars, and we will help institutions think strategically about operational readiness, communication planning, compliance practices, and institutional risk management during a period of rapidly shifting regulatory uncertainty. We are very pleased to welcome as our guest today Julie Wilbers, who is Director of International Student and Scholar Services at Vanderbilt University, and Adam Cohen, who is Immigration Attorney and Partner at Siskind Susser. An international educator with 20 years of experience spanning 4 institutions, including 2 academic healthcare centers, Julie has led international student and scholar services, immigration compliance, and international programming initiatives. Her experience includes visa sponsorship for students, scholars, and faculty and staff across multiple visa categories, employment-based permanent residency sponsorship, and oversight of international travel. Adam is a partner with Siskind Susser, focusing on the immigration of physicians, researchers, faculty, and students. Adam is a member of AILA's Department of Labor Liaison Committee and is on committees for the International Medical Graduate Task Force and NACUA. Adam is also active in NAFSA and previously served on the Regulatory Sessions Working Group, ISSRP, and Trainer Corps. He is the author of the Academic Immigration Handbook, which is updated annually. Before we begin, I'd like to share with you a brief word from our sponsor. Today's episode is brought to you by Gateway On-Demand Staffing Services. Might you be needing temporary ISSS staffing support? Well, Gateway provides experienced remote DSOs and AROs to help institutions maintain continuity during staff transitions, leaves of absence, and periods of increased demand. Whether you need additional support for a few hours a week or temporary full-time coverage, Gateway's on-demand staffing services help institutions maintain compliance and continue serving international students and scholars. To learn more, visit gatewayinternational.org/on-demand. And so now back to the show. And I'd like to remind you, just before I ask the first question of our guests, that we have a Q&A portal. And I'd like to encourage as many of you as possible to post questions or comments on this Q&A portal. And once we're done with the formal interview, we will have about 25 minutes. We know that there are hundreds of you who have registered for this episode, and so we decided to give an additional 15 minutes to answer questions and respond to comments regarding this very critical topic. So I'd like to encourage you to post your questions or comments in the Q&A portal. And so let's just dive right in and begin with the first question. And it's a rather basic and elementary type question. And that is, Julie, and you may respond, what is duration of status, or D/S, for F1 and J1 students and exchange visitors? And why has it been such an important feature for these categories of non-immigrants?
Great. Thank you so much, Harvey. And it's very nice to be with all of you today. I know some of you are joining us from around the country. I never thought I would use the words duration of status so much as I have in the past year. But to give you an overview, duration of status is the period that F1 and J1 international students and scholars are legally allowed to remain in the US. So rather than having an exact expiration date at this time, it lasts as long as they make normal progress toward their academic or research objectives or participate in authorized practical training afterwards. So, this proposed change replaces this open ended duration status with a fixed expiration date, like other visa categories currently have. But it would require them to file and pay for formal government extensions to stay in the US if their programs require more time. And we'll talk more about what that means later. But if you've worked with students and scholars in any capacity, many of you have, you know that pathways are not linear. The nature of where they are in life, the twists and turns that study and research takes, the life events that come up can shape a timeline. And domestic students, they can take breaks, they can change majors, take time off, but international students will now be on a more stricter timeline with less room for error, for things to go wrong. And historically, we as international offices have made those decisions internally, whether a student's eligible for an extension or they can transfer to another school. And that's been handled within our offices. And this is ultimately changing the focus of control, removing it from international offices. It will have to start with us, but to the government, and particularly US Citizenship and Immigration Services, which adds administrative and bureaucratic layers, uncertainty in an already unforgiving and slow immigration systems. And as you all know, universities are complex. As veteran international advisors, we know the very intricate processes and policies related to extensions, leave of absence, so on and so forth at our institutions. Vanderbilt alone, I think we have a combined 60 years of experience at the institution, and we know the immigration and institutional requirements, expectations, and so on. And now those decisions will be made by USCIS, and many of those adjudicators, I would assume, have limited understanding of how our institutions and study pathways operate.
Great. Thank you, Judy. Adam, did you want to add to that or?
Yeah, I mean, and I totally agree with everything Julie said, and she can obviously speak to what the need for duration of status is, better than I can as the outside immigration attorney. But I would note, that's an answer to the question of, well, why, should um, uh, F and J non-immigrants be treated differently than other non-immigrants, right? Which is really throughout the proposed rule, there is that discussion by the administration that it's sort of an issue of equity in a way, right? The other thing is that students and exchange visitors are already treated differently. There's a huge compliance regime, which is the SEVA system, right? And all of the professional, highly experienced designated school officials and responsible officers who are inputting information during all of these life cycle changes, right, across the student and exchange visitors academic and research journey, right? So this has been, I think it's important to understand the history here with this shift into duration of status that occurred really in the 70s. It was like in 1979. And at the time, it was a question of efficiency for the admission of non-immigrant students and a reduction in the workload for Immigration and Naturalization Service, right? Tasking foreign student advisors, as they were called at that time, with advising the service when students were no longer enrolled in school or when there were any type of changes. And this was, again, there was sort of a back and forth shift on DS. But ultimately in 1983 for students and 1985 for J1 exchange visitors, the duration of status policy was reinstituted. And it was based again on the service having very good compliance protocols in effect. At that time, a precursor to the SEVA system, like a computerized way of tracking students. And now we know that in the aftermath of 9/11, right, with the SEVA system, that F and Js are among the most tracked and monitored non-immigrants in the entirety of the US immigration system. As I was mentioning, right, DSOs and ROs are entering information constantly, program start dates and end dates and transfers and reductions in course load and practical training and moving on to, higher levels of education. And so, this shift is basically a solution in search of a problem, right? It doesn't make any sense. It's a redundancy to something that is already being addressed. And so, duration of status is really eliminating duration of status is just completely unnecessary.
Well, following on right on this note, this shift,
Mm.
can you explain, Adam, what the proposal would change in practical terms for students and exchange visitors and institutions?
Certainly, Harvey. So it's changing a few things. I mean, a lot of the focus has been around this, issue where students who are presently here or students who enter in the future are going to be admitted for this specific period of time, which is going to be the shorter of either 4 years or the program duration, the program end date that is currently on their I-20 or their DS 2019. And so if they want to extend beyond the period that they're given, they are going to have to extend through U.S. Citizenship and Immigration Services while they're here, or there are different rules related to travel and readmission through Customs and Border Protection, and receiving extensions. That means, right? So it is basically inserting these various checkpoints along the course of study or the exchange visitor program at which the government is going to be looking in and making sure that that individual is eligible for the extension. And that's obviously what's gotten a lot of the attention. It's also important to understand that while these extensions are ongoing, students are going to be able to continue going to school, but it is going to affect work authorization. So of all sorts, right? So that includes on-campus employment for students, curricular practical training, optional practical training, economic hardship, work authorization, academic training for J1s, and also the ability for exchange visitors whose work is incidental to their program, like research scholars, professors, clinical trainees, and graduate medical education. It's going to limit their ability to continue their program, perhaps. And this is this 240-day rule that you all might have heard of, this automatic extension that they receive. But what if those extensions take longer, right? And the other thing is even for curricular practical training, it's tied to the course of study. So
Right.
if that CPT is interrupted, does that also mean that the student fails to maintain status if the extension is not adjudicated after those 240 days, right? So there's a lot of implications there. Grace period reduction for F1 students from 60 to 30 days. And then there are these restrictions on transfer during your first, your undergraduate year, your first year of undergraduate studies, the entirety of your graduate education, and a 24-month limitation for English language students, and this lateral or reverse matriculation prohibition, right? So this bachelor's to bachelor's shift, they're making that, prohibiting that. They're prohibiting a shift of, let's say, a master's to a bachelor's degree, a reverse matriculation. So there's a lot of things, and it's, if we had more time, we could address all of the impacts of each of these. But there's probably plenty that we haven't even thought of yet in terms of what those impacts will be. The last quick thing I'll just say is that there's a transition period too. I think everyone needs to understand that there is no grandfathering, so to speak. Those who are present in the US now will, on the effective date of this rule, will have their status and ability to remain in the US limited by what is currently on their I-20 or their DS 2019 as of the effective date of the rule, which is 60 days after publication. And not to exceed 4 years, as I was mentioning. So those individuals who are present here, they're going to have that, let's say F1s, they're going to have that 60-day grace period because it's a reliance interest. They're expecting to have that grace period. But once they move to extend at the end of that period, or they move to travel after the effective date, that's when they're going to get the 30-day grace period coming back. So it's important to be aware of some of these transitional rules as well.
So Adam, you've actually shared quite a bit, and just listening to you, this is head spinning. It really is. The ramifications are quite profound. They're broad and they're deep. Um, Julie, is there anything else you wanted to add to what Adam has said? This very comprehensive. Yeah, go
Yeah,
ahead.
and I guess I would just add that we don't know exactly what the final rule will be like. The proposed rule still has a lot of unanswered questions, like that we're going to have to find out. Will there be guidance when the final rule comes out? Because I think there's a lot of questions that DHS hasn't answered. And I guess maybe just give some examples. So if you're a PhD student and you're admitted to the US, you're going to be admitted for 4 years. Now, you can, this is according to the proposed rule, you can request an extension to complete your program, but that initial admission of 4 years might be concerning to some students.
Mhm.
Another example is what if you are a graduate student and suddenly you can't transfer, but your principal investigator in the lab that you're working with moves to another university, and that happens all the time. What will you have to do? Will you have to change your research topic? What allowances will be made? Undergraduate students can't transfer for a year after arrival. Unfortunately, life doesn't work that way. We know that undergraduate students may struggle in a specific environment and then want to move to another school that is closer to their aunt or uncle, for example. And then I guess the final example is what Adam mentioned, lateral and reverse matriculation. Basically, let's say I wanted to do a master's of public policy in the US. And then I thought, you know what? A Master of Legal Studies would really help me before I go back home. I wouldn't be able to do that because that's lateral matriculation. Let's say I'm doing a PhD and I realize, I'm not really suited for a PhD. I want to leave with a master's. Now, hopefully you'll be able to leave with the master's, but you wouldn't be able to switch to the master's and then apply for OPT. So not to get into the weeds, just give you an idea of what that could actually look like in practice, knowing that the final rule could be different.
Okay, thank you. I kept thinking as you were speaking about how this rule would actually take effect, and the fact that it um, much will depend on the end date of the program. And so I was wondering whether what are some of the things that institutions may choose to do to not only respond to their obligations to comply with immigration law, but also to respond to the obligations to the students to whom they have a responsibility. Um, Put another way, with the institutions attempting to address compliance, we're talking about CVIS administration, advising, record keeping, and coordination between international student offices, academic departments, and legal counsel. So how might this proposed rule affect university compliance responsibilities in both respects, not only to immigration law, but and I guess I shouldn't be using the term compliance, but their obligation to advocate and be of service, if you will, and to advance the best interests of students and visiting scholars.
I mean, I think that's a great question. And I think Adam put it well that we're already doing so much more than people realize. But this is going to greatly enhance the level of responsibility, liability, and the sheer stress of what we do. If a mistake is made, and we may talk about this a little bit later, but it could result in accrual of unlawful presence now, which could create legal bars to reentry in the future. And I think just this lack of room for humanity means that we're going to have to be communicating more often with our students and scholars. We're thinking within our office about how can we change how we operate with our international students and scholars? Can we do yearly required maintenance of status modules? Could we do required check-ins with our international students? Now, that might not be feasible if you have 10,000, 20,000 on your campus. Can we work with our registrar's office to create international student holds if a student isn't responding? We're saying that they need an extension of their I-20. So I think this will require more frequent audits of our data with our registrars and admissions partners, with IT, and making sure we have the data accurate between all three systems, the student information system, that government CVIS system that Adam mentioned, and then of course the interface that we use. And since USCIS will be able to scrutinize students' applications, it also, in a sense, allows them to scrutinize us more. So we'll be working even more closely with legal counsel. If you don't have a good relationship or know your legal counsel, you'll get to know them rather quickly, hopefully. And we'll have to determine the extent to which we help students with these new filings. So currently, Harvey, or maybe in the past, if a student or scholar files, let's say, a change of status application with USCIS, most institutions are fairly hands-off because it's not our application. We can't give them legal advice. But what if all of a sudden many of our international students and scholars have to file these extensions? And their ability to stay hinges on these, not only their ability to stay, but also the ability of the academic programs who are trying to recruit not only the best and brightest within the US, but outside of the US, and relying on their immense knowledge. They're doing cutting edge research. How will they be impacted? So we'll have to think about in what ways can we mitigate these challenges? What resources are we going to have to expend? How can we collect all their I-94s? Because these are the documents that will have the new end dates. Do those end dates match what's in the system? Again, this all goes back to what Adam was saying, why the government created duration of status in the first place. But we'll really have to think very carefully about how we operate and how we interact with our populations and our campus partners even more closely.
Adam, would you like to add to this?
I don't think I could put it as perfectly as Julie stated it, but yeah, I mean, I would flag that there's going to be some concepts that will become more important to international student and scholar advisors, and to students as well that they haven't had to face before, right? So like customs and border protection, I would certainly imagine that we would be seeing confusion on their side and probably a lot more I-94 errors. But there's also something that for those of us who work with these date certain statuses like H-1Bs, we know that when somebody comes in through CBP and they have a passport that expires before the full period of validity of, let's say, their H-1B status in that case, their I-94 will be limited to the passport expiration. How do we flag this? How do we track this? How do we educate students and exchange visitors to be aware of this, to always be checking their I-94? There's the whole concept that Julie was mentioning about accrual of unlawful presence, which has not typically been as much of an issue for students and exchange visitors because they don't start to accrue unlawful presence toward these 3 and 10-year unlawful presence bars until there's a formal finding from a USCIS officer or for an immigration judge that they violated their status. But now you'll have more frequent check-ins with USCIS. If they deny that extension of status, that can lead to accrual of unlawful presence. And also for those who have a specific end date to their status, if one is within the US beyond that end date and they haven't extended their status, they will start to accrue unlawful presence. So these are concepts that ISSS advisors have to internalize, but also have to be able to message, to students. So I'm sure there will be a lot of collaborations with immigration attorneys as well, on trainings and orientations and things of that sort, and just trying to figure out, it's not just immigration attorneys, but any other outside service providers or technology vendors. How can we use technology to really help track and monitor? So those are the things I would add. I'm sure there's plenty more things to add.
Sure. Thank you. So the discussion we've been having for the past 20 minutes has been very technical. And I want to throw out a question that is maybe a bit more strategic. I'd like for you, and maybe Julie, you could take the first stab at this, to discuss the implications of ending duration of status for international student enrollment at American colleges and universities. The fact of the matter is many institutions depend on the tuition revenue provided by international students. So there is that, as well as the ability of institutions, particularly graduate programs, to attract the best and the brightest students from around the world. Would you like to comment, Julie, on this?
Absolutely. And I think it's interesting because we know the impact duration of status will have. It's probably not something that others know as broadly, but our international students, prospective international students and scholars are quite savvy. So many of them are becoming familiar with it. And I think it not just adds, but I think it adds to the precarity of coming to the US. So, I work with a lot of international medical students and international physicians over the years. And to use them as an example, do I want to invest all of this time and money and effort in the US and this medical program if I know that there's maybe some uncertainty, if all of a sudden it's not the international office that's going to be looking at how long I can stay here, but also a government agency. What about recruiting PhD students? What is their understanding going to be of duration of status? And, do they want to be filing extensions with the government when they have to pay filing fees? And would they rather go elsewhere? So I think overall, Harvey, it adds to the stress. I'd say the complexity of navigating the system that's already not easy, the uncertainty, and I think the sense of how they feel welcome here. And I think this all adds up, and I think it does exponentially. So if someone experiences a major setback, like a student or scholar, as we know, that story reverberates throughout their home. That could be their city or country. And that word of mouth is very important for the pipelines that come to the US. There are many other options, as we know, for students to study. Any student that's globally mobile, but that's growing outside even your traditional top English speaking countries. And there are many more countries that are ready to recruit global talent. So I absolutely think this will have a chilling impact on our international students and scholars, whether immediately or more long term.
Adam?
Yeah, agree with all of those points. I think that students, as Julie said, students are very savvy about this, about different changes with immigration and how it might affect them. And they're, no stranger to a lot of the policies. This is just one of a series of policies of the Trump administration, especially during this, this second term, where there's been sort of this onslaught toward academia, all of the social media vetting, the earlier SEVIS terminations that fortunately were stopped by litigation, the weighted cap selection process for H-1Bs, things that ultimately even affect that pipeline of students who are transitioning to post-graduation careers. Julie mentioned loss of market share to other countries. There are other options available to students in terms of world-class education. And I think that that's something that we shouldn't take lightly. And, I think that the arguments perhaps that tend to resonate the best with, the Trump administration are when you can really flag and highlight what will be the actual impact and effects, at least to some voices within the administration. We're looking at when you alter a pipeline of this sort, you do remove all of these talent workers from underserved industries, from making contributions that are vital to particular industries, including healthcare. We could all cite statistics, related to the role that immigrants have in entrepreneurship in the U.S. and creating businesses, becoming, world-class researchers and receiving Nobel Prizes, right? There's these just stunning statistics about those roles, and so it's really important to remember this when this environment is getting kind of this academic environment is being shaken up as it is?
A quick reminder about the Q&A portal and an invitation to submit questions or comments there. A number have already been submitted, and we'll try to get to them as soon as we wrap up this section of the spotlight. But I'd like to ask the final question by beginning to say that the proposed changes are still only proposed changes, and they've not yet been implemented. And of course, part of the reason that we're doing this episode is to make our constituencies as familiar as possible with the proposed rules, and maybe to begin thinking about how best to prepare institutionally if in fact it's implemented. And so in light of the fact that it's proposed and we're just thinking about it and trying to strategize as best as we can, what should colleges, universities, and other sponsoring institutions be doing now to prepare and strategize, and what internal processes would be most important to revisit before any final rule takes effect? And maybe, Julie, you could get started, and Adam can offer concluding thoughts.
Yeah, that's a great question, Harvey. And I'll try to keep this brief because I think that list is long. But, one thing I'd say is attend all webinars available. There will be many more coming out, especially after the rule comes out. So make sure you're watching the listservs, you're working with the experts, you know what this means, regardless of where you sit at the university. If you haven't already, develop regular meetings with key stakeholders. Legal, communications, your provost office, your graduate school, your postdocs. Of course, this impacts J1 scholars, federal relations, registrar. Make sure that you are already have regular meetings with them, frankly, if you can. If you're in the international office, if you're not already established weekly meetings or even more frequently, I think this will help ease anxiety. At Vanderbilt, we've come up with an Excel spreadsheet within our office to track what we have to do, who's assigned, what the timeline is, and what the completion status is. And this keeps adding up, but it gives us some sense of control. And this will also help your leadership see the immensity of the operational lift and what it entails if you have to advocate for more resources. I think really important, draft email templates if you haven't already with the help of your communications team. Be prepared to send those emails, such as even alerting the international population and your campus partners of, hey, this has happened. We will be spending some time reading it, digesting it, and we will be in touch. That helps them know that you're on top of this and that they expect information to come from you. Be prepared to have a list of all the campus partners you're going to set up meetings with once this comes out, so that you can send out those invitations. And once you've had time to digest this, of course, they'll be constantly unfolding and evolving. There could be a lot of unanswered questions. There could be litigation. So I think kind of be prepared to be nimble and stay on top of that information as it comes out, and make sure that you're including those key partners, especially legal and federal relations, as this goes on. So there could be more ideas, but I'll stop there for now.
Adam, any
Yeah,
thoughts?
I would just add also, including HR, obviously, in those kinds of discussions as well, when the final rule comes out, especially just related to that 240-day work authorization piece, and making sure they're in the loop and understand that. And talking with, as Julie was already saying, just talking with general counsel, being aware of the just liability and resource considerations in terms of how involved universities are going to actually get in the 539, at this point, the 539 filing process for those extensions.
Great. So I'll pivot right to the questions now, and the first one that I think is really important here says, if you are offering longer extensions, is there any concern that this could be considered skirting around the law? What are your thoughts about this, Adam?
Okay. Skirting around the law. No, I mean, I think that at this point, this is something that is still kind of within the domain of universities, right? In terms of the length, and Julie, you can tell me if you think otherwise, but the length of a course of study. And so I wouldn't think that there would be any issue with that. I would say, Jess, if you are issuing like let's say an I-20 or a DS 2019 that is beyond the 4 years, um, it you really have to be careful about the messaging to your students and scholars because they could see an I-20 or DS 2019 that is, extended out for 5 years, but they actually only have status for the 4 years. So it may be helpful to kind of keep it consistent with the maximum that that student or scholar would receive. But no, I don't think that there's any issue with as long as it's academically justifiable or it's in line with internal university policies with extending it for more time.
Yeah, and I'll just add to that, that's something that we did. We reached out to all students, especially if their I-20 end date did not match their expected graduation date in the system. We encouraged them to submit an extension request. PhD students in particular, we even reached out to department administrators and said, hey, if you have a J1 scholar like a postdoc that you anticipate to be here longer, submit those extension requests. I think sometimes as international offices, we can be a little bit overly cautious. But if they're, like Adam said, if there are justifiable reasons, why not get those extensions in now? Now, of course, it can't go beyond those 4 years. But I think do whatever you can right now, especially when you still have the control over what those I-20 and DS 2019 end dates look like.
Great. Next question. Can you speak a bit more about travel and re-entry options for students? For example, if a student wants to transfer to another school to a lower educational level, like reverse matriculation, would they have the option to leave and re-enter if their visa is still valid? Julie?
Honestly, I don't know if that's clear in the proposed rule. I think that's something we still have to figure out. So, like currently, if you're changing your status, you have the option to do that within the US or travel and reentry. So we don't know if that's going to be applied to this rule. So Adam, I guess the question is, let's say I want to transfer, I'm a graduate student, can I never transfer, or does that mean I have to go
Yeah.
through USCIS, or does that mean I have the option to leave and re-enter to do that? And do we know the answer to that question yet?
I wonder, I was trying to find out. I feel like this is in the preamble somewhere. I was looking at a quote that basically said a student who's completed a program as an F1 at one educational level would be unable to maintain F1 status, depart and be admitted in F1 status, or otherwise obtain F1 status through a program at the same educational level or a lower educational level. So I actually think it contemplates both a situation where you're present in the US and trying to transfer, or departing and coming back into the US to pursue something at that lower educational level. I think that they're putting these restrictions in place whether one is present in the US or whether they're traveling. That's my that's my understanding. But as Julie said, there's going to be so much that's going to unfold in terms and will need to be clarified whenever the final rule comes out.
And this is actually my question, which is when the final rule comes out, do you anticipate litigation? And do you anticipate that they would come from universities or from private industry or other organizations that have an interest in how this rule will impact the experience of international students and scholars in the United States and their willingness even to come to the United States?
Yeah, I can comment on that. I mean, we've certainly been hearing whispers of the possibility of litigation, but of course, we don't have a final rule. We don't know what it looks like. We
Mhm.
don't know what type of commentary has been provided to the, 21,000 comments that were received and how they address those. So It's not, it's not entirely clear yet, but I would imagine that there would be some type of litigation. As to where it would come from, it could be university organizations.
Mhm.
It could be institutions themselves that have been involved in litigation in the past. The unlawful presence memo during the first Trump administration, the Department of Labor ruled to increase prevailing wages. Universities were a significant part of a lot of this litigation. Maybe even from public universities like attorney generals in particular states. There could be some litigation from there, just like we saw with the H-1B fee proclamation. And in terms of what would sort of be the basis of that? Well, they have gone through Administrative Procedure Act notice and comment rulemaking. So they've gone through what they need to go through. That is the correct process. It's going to be harder to attack on that basis, but it doesn't mean that you cannot if the government has acted in an arbitrary and capricious way. Some of the data that they rely on is somewhat suspect in terms of being a means to create this, eliminate DS entirely.
Mhm.
In terms of whether there could have been less restrictive means that were provided. The data they did provide was a very small amount of data of F1 students that they believe had overstayed. There was no commentary that I could find related to any issues they had with J1s. Was the cost benefit analysis flawed in terms of what they anticipate the cost will actually be? And, there's also this aspect of the Loper Bright Supreme Court case, which eliminated Chevron deference, which is, the deference that courts typically accord to agencies when they engage in the creation of rules. That deference is no longer there. There is a de novo, basically brand new review that courts provide when they assess whether a rule, an agency regulation is proper. So I think there are some fertile grounds in which to, engage in litigation. We'll just have to see what that ultimately looks like.
Mhm. Great. Since there is no grandfathering will the amount of time a student has already spent in the country count towards their 4 years? And what would it look like if a student is here, has already been here for, say, 5 years? Would they need to retroactively fill out an extension?
Oh goodness, I hope that's not the case. They'd have to retro. My understanding is that the end date, and Adam, correct me if I'm wrong, of the I-20 or DS 2019 for those already here will become their I-94 end date. Is that correct? Yeah.
That's what I understand, right? So here you are, student, student A, I don't know. I don't think I have a student B in this scenario, but student A is, present here in the US as of the effective date of the rule. Again, that's going to be 60 days after the final rule is published. And here they are in the US. They now, whatever their I-20 or DS 2019 is, on that date becomes their I-94 end date, is my understanding, right? Plus, for students, the 60-day grace period, because they're still present in the US, 60 days, and or 30 days for the DS 2019, right? And that's, not to exceed 4 years, obviously not to exceed the, 24 months for ESL programs, not to exceed the standard regulatory limitations on different J1 categories. So, but apart from that, it's going to be the end date on the I-20 or the DS 2019.
Okay. Um, can you talk a little bit more about how this will impact curricular practical training and optional practical training?
In terms of optional practical training, this doesn't get rid of optional practical training. I know there's some concern about that. Our understanding, though, is so currently when a student applies for OPT, they work with our office and then they get a document and they apply with USCIS to get their OPT card. Our understanding is that they could have to apply for an extension and the OPT at the same time. So, and I know one of the questions in the chat looked at processing times. USCIS, my understanding that they're not staffed at the levels that they need to be able to process so many of these applications. So I think one of my concerns is USCIS going to be able to keep up with these applications? Will they create a process, Adam? I don't know if you know, where a student can file that extension of status and that OPT application at the same time. It adds to the cost of OPT, and I think it adds to the uncertainty if there are delays and how that would impact their employment. I'll let Adam comment on that if I missed anything. With CPT, this shouldn't have a direct impact necessarily, but I guess, as Adam mentioned, if they're waiting for their extension to be approved, and if they're beyond that 240-day grace period or whatever that ends up being, they would have to cease. Our understanding is other benefits such as curricular or practical training. Adam, anything to add to that or?
Yeah. Thinking of a few things. I mean, the first thing, sort of broadly speaking, right, when I think it's to understand, since we didn't address this earlier, you know, what does the government want to do at these checkpoints, right? These extension of status checkpoints. They're going to be looking into a lot of things, but that includes maintenance of status, right? And whether someone is progressing in their course of study. CPT has been scrutinized largely day one CPT, I think, more than anything else, right? And so you have to imagine that there's going to be a lot more looking into the day one CPT and sort of what the student is doing as part of that CPT during that extension of status checkpoint. That's one thing. Um, and the other thing I just wanted to mention in terms of the transitional impact, if you are filing this post completion or STEM OPT within, I'm trying to remember exactly the rule, so it's within 6 months following the effective date of the rule, you are able to remain in the US even if the I-20 or the DS 2019 is kind of cut off. You can remain in the US with that pending OPT or that STEM OPT, or even when it's approved, you can remain without having to file an extension of status. So what I'm getting at is there is a transitional rule related to OPT, STEM OPT, but ultimately, as Julie mentioned, there is going to be a need to file for both extensions of status and the work authorization application. In a
I
way,
think
I think a ways that's similar to how it's used in the M1 world.
Adam, I didn't even think about that I
Yeah,
mean, the extent to which they're scrutinizing CPT already. In many of our
yeah.
offices, we have, fairly liberal CPT policies because the regulation is not quite straightforward. But as they have more of these checkpoints and as they're scrutinizing more CPT, that could change how we operate and how we are able to issue CPT, knowing that we could expect more scrutiny and how that could impact the international student in some of these adjudications in the future. That's a good point, Adam.
Well, it also leads to, scrutiny that, um, a student might face for an extension, right? If USCIS doesn't believe there's some compelling reason, academic reason or things of that sort, right? Like what's currently in the regulations for those extensions. They're basically, they're checking. It's like the decision is being made by the university, and then the decision is also being made probably in a much more stringent, restrictive way by USCIS.
Mhm. Thank you for that. Next question. I gather that students admitted to dual degree programs would violate the program change rule when they pivot from being primarily in one degree program to the other. Is that your understanding? Adam?
Trying to think of what that would look like in terms of just sort of an example of that. I don't know, Julie, do
Like,
you have any initial thoughts
well, you
on?
mean like an
Yeah.
MD, PhD, or like an
Mhm.
MD, MBA, where they're enrolled in two programs at once, and at
Yeah.
any given time, they're working on one of those programs. I think the MD, PhD is probably a good example. So I guess the question is,
Hmm.
and I think this kind of goes to how this is going to unfold because currently I'm trying
Yeah.
to think we have, I guess, both on the I-20, major one and major two. So will the student be able to be both at the same time?
Right.
Or will there have to be some formal mechanism to report that to USCIS? And I don't have an answer to that question other than, they will be limited to the 4 years, and many of these programs are 7 to 8 years currently. And I think that depends on how they operationalize this, Adam, and what that means for, what a change of major even means, honestly. Are you changing your major if you're already admitted into a program that has both majors?
Right.
Right.
Yeah.
Yeah.
Okay, moving right along, and Julie, I'll direct this to you. How will this impact IEP, intensive English language programs, or ESL programming?
I think that limit of 2 years, I think, is crucial to be aware of. I think also, like if there are extensions or if there's a gap in a student's, academic program, how will USCIS evaluate that? On what basis will they look at those extensions? What else, Adam? Anything else with IEP programs that come to mind in particular?
Well, the thing that in the preamble, so they basically came up with this 24-month period because they said that this comports with the amount of time needed to gain the highest level of English proficiency. I'm reading this here. The highest level of English proficiency under the Cambridge English exam. But they're basically using one source. And some of the comments that I've seen, that have come out of the English language training, organizations has been that, there are a lot of other sources, right? And there may be a need to pursue, to really truly pursue English language proficiency may take longer than those 2 years. So I think that that's, sort of flawed, not saying it's flawed data in terms of using the Cambridge English exam, but it's that like there weren't other sources that were considered. And so that can be an issue. And I think that it could also be an issue when you have this block of the ability to transfer, right, within the first academic year. How does that interplay if there are a changing of English language programs? And also on the reverse matriculation front, right? So, a scenario maybe where someone is going from an undergraduate degree, let's say, after they finish that, so that they can pass exams like the GRE, to get into a master's degree program. Maybe they would want to take an English language program before they then move on, right? So now we're talking about a dip, right? Undergraduate reverse matriculation to English program, and then progression to a master's, right? It's that dip. It could be perceived as a reverse matriculation thing. So it's like this is what happens when you have these bright line rules that you just put into place. That there will be certain failures to consider issues and industry impacts and the necessity of, in this case, lateral or reverse matriculations and transfers.
It puts everyone in a box, a one size
Right.
fits all. And, we have undergraduate students at different schools that may not feel like they have the English that they thought that they wanted, and they may want to transfer to a school and back. So it definitely changes that fluidity that accounts for, the humanity of students and scholars and what actually happens, how these things play out in real life.
Great, thank you. Um, Just to the viewers, I am not asking every single question because some of the questions that have been posed, I think, have already been addressed. So do bear with me as I try to get through these. We have about maybe 4 more minutes, and maybe we can get two additional questions in. First, would students in graduate level programs with concentrations be able to change their concentration within their major? Or would that be considered a change of program of study? Any one of you could respond to this.
Yeah, I mean, I don't know that that is specifically addressed in terms of the concentration, right? Like they're talking about because I mean they're talking about in terms of graduate level, um, they're talking about transfers, I think, in the graduate level, um, that those are prohibited. I don't see how the concentrations would be impacted, though. I mean,
And
there is sort of some verbiage about educational objectives, but
mm,
I would say that we would need to see more clarification. It would not be immediately obvious to me, based on a read of this rule that changing a concentration would be prohibited.
yeah, we haven't been anticipating that, but who knows? I think that does go back to the
Mhm.
educational objective. And I think a concentration, depending on how that will be viewed, could be a way to work through some of these concerns, especially if you're admitted to a PhD program that's very general to begin with, like biomedical sciences, and then, you would choose your major later. Could that be the concentration? Is that concentration on your I-20 in the major field number two? So I think it's going to depend on your institution's current approach and then what those guidelines look like and then how you adjust. But I would say, regardless, once we have more information, meet with those academic programs and come up with a plan of action before that implementation, that 60-day implementation period is over.
Great. Thank you, Juliet. Squeeze in one final question. Is there any guidance on what factors might influence a decision to approve or deny an extension? Uh, Julie, did you want to take that?
Hmm. An extension with USCIS. Well, I think that goes back to one of the things that Adam was saying, like in the regulations, it talks about compelling academic or medical reasons. It does mention that probation and suspension are not a reason for an extension. So I don't know if they'll be looking very strictly at the regulations, if they will include input from international advisors and international offices, or what's going to constitute, a compelling academic reason. I mean, for us now, a change of your research, or you need more time to complete your dissertation. I don't know if that's something that they're going to factor in. Adam, do you have any guess there or
Well,
concern?
I mean, I think I would add it, Julie, in the non-academic context in terms of other things that they might be looking for, so they're going to be doing biometrics. They're going to be looking at any type of criminal issues. They're probably going to be, this is their opportunity to look at everything. They can look at, social media accounts and online public presence. As I mentioned before, scrutiny over maintenance of status. Looking at intent issues, I thought was sort of an interesting aspect, right? Because we know of a lot of Fs and Js that have green card processes ongoing as well, particularly if they're in the final stage of that and they've like an adjustment of status application. Is that going to play heavily into consideration whether they merit an extension of status? They can look at financial resources, which they already scrutinize very heavily in changes of status to F1. So we might see looking into that. Um, they talk about possible interviews. I think that that would be in probably an unlikely situation. But anything else that they believe they have discretion to review because they do feel that they have discretion for 539 applications, which would be the form that this extension would be on as of now.
Well, we are at the end of this show. Thank you, Adam and Julie, and everyone who joined us live or on replay. And stay tuned for the next Gateway Spotlight titled The Hidden Risks of Global Engagement in Higher Education. In the next episode of Gateway Spotlight, Senior Leaders in International Higher Education will examine the evolving institutional risks associated with global engagement and the growing need for a more coordinated enterprise-wide approach to international activity. I invite you to visit the link in the chat for more information. And again, before we go, thank you to our sponsor, Gateway On Demand Staffing Services. Gateway provides experienced remote DSOs and AROs to help institutions maintain continuity and compliance when additional ISSS staffing support is needed. To learn more, visit gatewayinternational.org/on-demand. Thank you so much and see you next time.
Thank you, everyone. Thank you, Harvey.
Thank you.